name is Kimberly and welcome back to our channel. Today we are in Białystok, Poland at the Law and Mediation International Conference, and we have some clips for you from mediators and experts and lawyers all across the world.
And we're going to Portugal. Thomas Gaultier is a mediator and New York qualified attorney, currently of counsel at Abreu Advogados in Lisbon, Portugal. He has authored various articles and book chapters on the topic of mediation and ADR, including an award-winning paper entitled Cross-Border Commercial Mediation. Thomas also teaches mediation and negotiation in two of the Portugal's best law schools. Thank you so much for being with us today. And thank you for having just one slide, which makes my life much easier. And the floor is yours. Thank you.
Thank you, Cesar. Thank you for all being here. Thank you more specifically to the Polish Bar Council, to the Mediation Center at the Polish Bar Council, to the Białystok Bar Association, to the University of Białystok Faculty of Law hosting us today, and to the Chamber of Industry and Commerce in Białystok. Thank you very much for the introduction, Cesare. I'm going to talk today about something that's been going on in Portugal for the past 20 years, and that has a lot to do with a topic that Mary Lou mentioned, which is empowerment. And I forget. Okay. And my topic is an entire parallel framework that the Portuguese government has put in place since the very early 2000s, which allows virtually any citizen for small claims to access justice, including through the use of mediation. And this is where I'm going to spend all my time. Okay. So this parallel justice system is what we call the justices of the peace. It's similar to small claims, except that it's all organized as a partnership between the Ministry of Justice and municipalities and cities. So if a city is observing that they're having an increased rate of conflict in their jurisdiction, they can request to the Ministry of Justice a partnership whereby the city will provide a place, some staff. That place and staff will be sponsored by the Ministry of Justice in order to answer some of the needs to solve conflicts. The whole purpose behind this, like I said, is to provide a venue for citizens to be able, at a very, very low cost, and in a very, very quick manner, to obtain some form of justice. And the principles behind this whole justice system, because it is a system, is governed by three main ideas. The first one is flexibility. Flexibility. As you'll understand when I explain the process, it's a very easy to understand and extremely flexible process. Another one is it's an oral process. So you have very, very little written procedures in this justices of the peace system. And finally, it's the absolute economy of cost. So in order to keep things extremely cheap. How does it work in terms of the procedure? As you would imagine any kind of litigation, there has to be an initial claim. But the difference here is that you present yourself to the Justice of the Peace office, and you basically explain what your problem is. And the clerk is there writing down in an A4 size piece of paper what the problem is. You can also fill out the paper yourself. But this goes to tell you that even people who can't read or write can actually access a system of justice. So they can come in and explain what their problem is. And the clerk will write down what the problem is. Then the other side will be notified that there is a claim against them. And at that point, both parties will be asked whether or not they want to use the mediation service of the Justice of the Peace system. If both agree, then a mediator who is trained in mediation, certified by an organization authorized to provide training by the Ministry of Justice, so competent mediators, the parties will advance to a mediation stage. If the mediation is successful, wonderful. Right? The mediator has the chance to sign the mediation settlement agreement, and that settlement agreement will have the same force as a first instance court decision. If the parties are unsuccessful in their mediation sessions, then they are summoned to a hearing. Before the hearing, however, the judge of the peace, who is not a professional judge, hasn't gone to judge school, but is somebody who is trained in law, and through a public exam, they can be selected to act as justices of the peace. The judge of the peace, before hearing the parties, will always try conciliation. Will always try and see if there is a possibility for them to reach a settlement. If they don't, then the judge will, of course, render a decision. So one of the main focuses here is promote settlement. All this, in terms of cost, is really easy, it's really simple, and it's going to cost the parties 70 euros. So I think it's multiply that by 4 to get in zloty. 70 euros if they don't reach a settlement through mediation, so if they go all the way to court. If they do reach a settlement through mediation, it is reduced to 50 euros. Okay. So talk about easy access to justice. Now, of course, not all cases can use this kind of system. You don't have a multi-million-dollar euro claim being solved this way. There is a cap. But the cap, surprisingly enough, is all the way up to 15,000 euros. So that's a lot. A lot of disputes can be resolved this way. Now the duration, because it is so flexible and so easy, the average duration for a solution to be reached through the use of the justices of the peace system is 3 months is the average duration before the parties get an outcome. 3 months. I mean, if I look at the rest of the legal panorama in Portugal, where the average time you would need to get a first instance decision in a first instance court, where it's between 1 and 2 years, when you think about 3 months is not much at all. Okay? And the outcome, like I said, is going to have the same force as a first instance court decision. Now, is this working? And I'm going to talk a little bit about statistics to share with you that whether or not this is working. Yes, to a certain degree, and no to a certain degree. And I'll explain to you why. Statistics for 2018 show us that throughout the country, bearing in mind that there are 25 partnerships around the country, so the Ministry of Justice has entered into 25 agreements with 25 cities to establish a justices of the peace system. Okay? There are more than 25 cities in Portugal, so it only covers a very small part of the country, but it's already a good effort on the part of those cities and of the country to try and stimulate access to justice. Okay? Over 8,000 cases were opened in 2018. 8,590 were closed. We had some pending cases from 2017. And about 30% of those cases went to mediation. You might say, that's not a lot. And it is not a lot. I'll explain a couple of drawbacks that the entire system has, but it is not a lot. But it's still something. And it's been increasing every year. In terms of settlements, like I told you, the whole purpose is for the judge of the peace to promote settlement through offering mediation services, through trying conciliation to help the parties settle, and always leaving a little bit of time to give the chance to the parties to try and settle themselves out of court before the ultimate hearing. 39% of the cases are actually settled. So it goes to show you, not all cases are settled in mediation. Some of them are also settled outside of mediation through conciliation or direct settlement discussions. Regarding the mediations themselves, 50% of those end up reaching a settlement. So as an American living in Portugal, when I see 50% success in mediation, I'm used to a higher percentage of success. But then I remember this is Portugal. They've only discovered mediation not that long ago. Our mediation law is only dated in 2013, so everything is still quite recent. So for me, 50% of cases that go to mediation is actually quite encouraging. There's always feedback that is sought by the Ministry of Justice regarding this system to try and understand, okay, are people actually liking this? Are users liking this? And in the satisfaction surveys, we come to see that 2/3 of the parties actually enjoy going through the process. Why? Probably because they feel very much empowered. Probably because they understand what they're doing. Because they just have to talk to the other person. And they have someone, whether it be the neutral mediator or the judge of the peace, trying to conciliate the parties or promote out-of-court settlement. They really feel heard. They really feel like they have the chance to talk, explain, argument, defend, and it gives them a sense of ownership of their own dispute and, more importantly, of their own solution. And so even though they don't always find a settlement, and a lot of cases still end up being decided by the judge of the peace, they still end up very satisfied with the entire process. Plus, if it's only 3 months and it costs you 70 euros or 50 euros if you reach a solution, it makes you very good about yourself. Because you're like, yeah, I managed to obtain justice for myself at a low cost very quickly, whilst having had a say in how I want to solve my problem. Okay? What are some of the few drawbacks, however, that in my opinion prevent mediation in this system from being even more used? The first thing is clerk awareness. Unfortunately, the mediators have fantastic training, it's very positive, but the clerks helping the parties navigate the process, they rarely have mediation training. So when the parties come to the clerk and say, oh, what is this? I have to tick a box. Would you like to use mediation to try and solve your dispute? If the clerk doesn't know what mediation is, in a large number of cases, the clerk ends up saying something like, oh, you don't have to worry about that. Just put an X in the no, okay, and you can go straight to court. Okay? I have heard lots of feedback of this happening to parties because simply the clerks working at the Justices of the Peace offices have very limited training and don't really know what mediation is. So that's something that I'm currently working on trying on changing. The second thing is the mediation format. Yeah, very good. Is the mediation format. Unfortunately, the mediation format has been inspired by a Brazilian small claims system and transposed directly into the Portuguese legal framework. Okay? And they created an online platform to help organize the hearings before the judge of the peace as well as the mediations, and they organized it in time slots of 1 hour. Okay? So that means when the parties want to go to mediation, the system automatically allocates one hour time slot, and it summons the mediator and the parties to that 1 hour time slot. Now, 1 hour to do mediation, it's not a lot. It's not a lot. And if you consider that in Portugal, mediation is facilitative mediation, so the mediator is not supposed to make any kind of suggestion or proposal or give their opinion. Okay? That's stated in our mediation law. That means you probably need a little bit more time to try and understand, apply all those mediation techniques, whether it be reframing, whether it be active listening, questioning, summarizing. So it usually takes longer. And the parties, they do one session. Do we want to do another one? Because it's going to be the following week or 2 weeks after for another 1 hour increment. And that usually hinders the success of mediation sessions. And the final thing that is greatly hindering the mediation services provided by the Justices of the Peace system is the mediator compensation. Okay? This is a very cheap method, as you all understood. Right? That means that we shouldn't overburden the state with, imagine we'd have a mediator charging 1,000 euros for a mediation. that wouldn't be very sustainable for the government. It would be great for mediators, but it wouldn't be very sustainable for a government trying to have a very inexpensive system to solve problems. So unfortunately, the law provides that the mediators get exactly the same amount regardless of the number of mediation sessions. The first hour, that's always included. The second hour, they don't get anything else for that. The third hour, fourth hour, 10th hour, if the parties need more time to reach a solution, the mediator does not get paid more for the extra time that they spend helping the parties. Now that for me is one of the greatest drawbacks of the system because it ends up creating a situation where the mediator might strongly encourage, if not force, and I have heard horror stories where a mediator within the first 5 minutes, I've looked at your case, this is what you should do. Yeah, that goes against everything that mediation in Portugal stands for. And that's unfortunate, but the system is like this. It's one of the downsides of this system. Now, the good side is that the parties still pay the same thing. So it's great for the parties who can have access to justice. But there are some drawbacks, and potentially once we will have solved and overcome these little technical issues that, in my opinion, have a great impact on the success and use of mediation, such a parallel justice system ensuring better access to justice, empowerment by the parties, for the parties, short duration, low cost, it's going to boom in terms of its use. That's what I'm hoping for. Now, all of this hopefully gave you a very short but somewhat comprehensive overview of what we're doing in Portugal. And part of the message that I usually try to transmit when I talk about this system in different countries is, learn from our mistakes. If ever you're trying to implement any kind of mediation system, it's great to recognize and empower the parties, but also make sure you recognize and empower the mediators. And by limiting that compensation of mediators, regardless of the number of sessions, you are basically hindering the recognition of the mediators. Now, mediators should, they're very selfless and humble, but only to a certain limit. Only to a certain limit. Now, this system in Portugal has been amazing for young mediators who finish their training. They have a hard time entering into the private mediation market, which is pretty competitive because it's not used that much, so only the more experienced mediators tend to get the private mediation cases. But it's great for young mediators who are not always young in age, but recently trained mediators in entering into the mediation business or the mediation practice. They're not getting paid very much, but at least they're getting a lot of experience. Because there are a lot of cases. And if you're in a city where there are a lot of mediations taking place, it's a very good way to get training, to actually be in front of parties. Because a lot of times, if you're recently trained in mediation, that's one of the hardest things, starting to actually mediate. I hope this has at least given you either a spark of hope or a spark of interest, or both, if you ever want to develop a mediation system or help your local government. Remember, these justices of the peace are all done at a local level. Your local governments or your bar associations or your chambers of commerce in implementing an effective way of empowering parties to help them solve their disputes. Thank you very much.